Good morning. I hereby call to order this first meeting of the Pennsylvania Public Utility Commission for the year 2019 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As always, we'd like to note the safety information on the inside of your cover in case there is a reason to evacuate the room. So the first matter on this morning's agenda is the approval of the minutes for the meeting of December 6, 2018. And I recognize Commissioner Kennard, who is the editor.
Good morning, Madam Chairman. I've reviewed the minutes of the December 6th, 2018 public meeting and recommend they be approved as submitted.
You have heard the motion of Commissioner Kennard. Is there a second?
Second.
Second by Vice Chairman Sweet. Is there any further discussion or edits of the minutes? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. And now we recognize our Secretary Rosemary Chiavetta, who will lead us through today's agenda.
Good morning, Madam Chairman and Commissioners, and Happy New Year.
Good morning.
Your various bureaus and offices have prepared the following agenda for your consideration. Therefore, let us begin on page 1. It is recommended by Director Gramola and the Bureau of Administration that the Commission approve the Evaluation Committee's choice for Human Resources Legal Counsel Services.
Is there a motion to adopt the staff recommendation?
So move.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2 and matters presented by Director Monahan and the Bureau of Audits. It is recommended in an omnibus motion that the Commission adopt both items on page 2.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3, it is recommended by Director Bechtel and the Bureau of Consumer Services that the Commission adopt and release the staff report regarding energy affordability for low-income customers.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion?
I have a statement.
Vice Chairman Sweet.
Thank you. Before the Commission today is a staff report entitled Home Energy Affordability for Low-Income Customers in Pennsylvania, prepared by the Commission's Bureau of Consumer Services, BCS, and the Law Bureau, in compliance with Commission order entered on May 5, 2017 at this docket. That order directed staff to initiate a study to determine what constitutes an affordable energy burden for Pennsylvania's low-income households. And based on this analysis, whether any changes in the Commission's Customer Assistance Program, CAP, policy statement, or other Universal Service and Energy Conservation Program guidelines are necessary to bring these programs into alignment with any affordability recommendations. The recent finding that households in Pennsylvania that fall below 50% of the Federal Income Poverty Guidelines, FPIG, are billed an average of 30% of their incomes for home energy costs. And that in many ways was the genesis of this study. It necessitated the need for a closer examination of our utility-sponsored assistance programs, which are admittedly complex and challenging to interpret given the variances in program offerings by each utility. I would like to commend the Commission staff, and particularly BCS, for rising to the challenge and producing a report that, despite certain data-related setbacks, proves to be a critical first step toward better understanding these issues. The information obtained as part of this investigation will inform the Commission's complementary ongoing evaluation of universal service programs generally. As part of this proceeding, the Commission is releasing staff's report for public comment, and as part of the comment period, I would like interested parties to also consider a few additional points of inquiry. LIHEAP. LIHEAP grants had a measurable impact on energy burdens for CAP customers across all poverty levels and energy types during the study period. The study concluded that CAP customers with incomes at or below 50% of the FPIG experienced energy burden decreases of approximately 5 to 6 points for gas heating, 6 to 8 percentage points for electric non-heating, and approximately 7 to 9 points for electric heating. However, only a relatively small subset of confirmed low-income households actually apply and receive LIHEAP, cash or crisis benefit grants. Given the correlation between energy burden reduction and the receipt of LIHEAP benefits, I would request that EDCs and NGDCs, as well as any other interested party, further comment on the following. How, number one, how, if at all, are LIHEAP applications encouraged at the time of CAP enrollment? Are there ways the intake process could be improved to ensure dual enrollment in both programs? Secondly, what are the known or perceived barriers to LIHEAP enrollment, administrative or otherwise? Third, what would be the advantages or disadvantages of requiring a LIHEAP application in order to receive CAP benefits? Secondly, in terms of energy burden models, the study states that Pennsylvania's maximum energy burdens in the CAP policy statement are higher than the maximum energy burdens in neighboring states. For example, Pennsylvania's energy burden levels are anywhere between 5 and 17%, depending on the energy status, fuel source, and household income, whereas Ohio's maximum energy burden threshold is 10%, and New Jersey, as well as New York, is 6%. The study covers cost projections of aligning Pennsylvania's energy burden thresholds with those of several surrounding states, and specifically Ohio, given similarities in state demographics and energy use. And the order directs EDCs and NGDCs to provide additional analysis regarding the potential financial impact of making these changes. In addition to providing various financing scenarios, I ask interested parties to provide comment on program design attributes adopted by neighboring states that may also be worth considering here in Pennsylvania. Specifically, first, New York has limited the budget for each utilities payment assistance program to 2% of revenues for sales to end-use customers. If energy burden thresholds are lowered in order to make energy bills more affordable for low-income Pennsylvanians, should a cap on customer assistance spending also be considered? If so, what would the financial impact of a 2% cap on revenues from sales to end-use customers be? How would this change affect current cap customers? Secondly, New York utilities recover their payment assistance costs from all rate classes. If Pennsylvania adopted a similar policy, what impact would cost sharing have on all participating rate classes if Ohio or New York energy burden targets were adopted? The above-mentioned scenarios are simply examples of policies from surrounding states. If there are other models or cap design elements worth consideration, I encourage interested parties to explain such benefits and the subsequent cost of part of these processes. This topic, and by extension all matters of universal service to low-income customers, are issues of great importance, and I look forward to reviewing the comments as they're filed. Thank you, Madam Chair.
Thank you. Any further comments?
Yes, I also have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I read it in its entirety. As noted, this is the first comprehensive energy burden and affordability study of Pennsylvania households undertaken by the Commission using customer income, billing, and payment information. The report contains a substantial amount of data representing a significant contribution of time from the Commission, utilities, statutory advocates, and other parties. I would like to personally thank the Bureau of Consumer Services for their works, particularly Sarah Dewey and Joe McGee, who've done yeoman's work over an extensive period. While I congratulate them for their perspective, their perseverance, and skill, there remains work to be done. In 2017, the Commission ordered the Bureau of Consumer Services, in conjunction with other bureaus, to undertake a study to determine what constitutes an affordable energy burden for Pennsylvania's low-income households, and, based on this analysis, whether any changes in the Commission's CAP policy statement or other universal service and energy conservation guidelines are consequently necessary. While today's report presents the gathered data and staff's analyses, noting variable reporting standards and specificity, valid empirical conclusions regarding affordability have not been proffered. Consequently, in addition to the specific data requests by the Commission staff, I'm requesting that interested stakeholders comment on the following questions and observations. What analysis is left to be done, and are there meaningful trends that the report has yet to illuminate? Additionally, I encourage the parties to ground truth the material and offer additional insights if supported by the data we have in hand. While at this juncture, staff make no recommendations per se regarding affordability, the report highlights and forecasts future program costs based on the affordability threshold of 10% utilized by the state of Ohio, as noted. Is a 10% threshold appropriate given the movement of other states to 6%, with Oregon most recently announcing that households spending more than 6% of their income on energy-related costs are considered energy burdened? What have the results been for ratepayers and program participants of Ohio's adoption of 10%? Also, of analytical concern is how the adoption of a flat affordability threshold might impact consumers compared to the income tiered thresholds currently in place. Would a flat percentage be harmful to consumers, especially for those at the lowest tier of the federal poverty income guidelines? This staff report clearly identifies that this group is already burdened under the current guidelines. It is worth noting that based on current Commission affordability guidelines, households which now might only pay 7% of income may see their obligations rise under a 10% threshold. Is there reason to believe that this upward adjustment would be untenable? As I highlight, there are questions that are yet to be answered before we can put forth a final recommendation. Of course, we anticipate this to be put forward in conjunction with our recommendations regarding the Universal Service Docket. I look forward to the continued engagement of stakeholders as we progress. This continues to be an important and complex undertaking, a task to which we remain committed. Thank you.
Thank you. Any further comments? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4, in matters presented by Director Sophie and the Office of Special Assistants, it is recommended in an omnibus motion that the Commission adopt both items on page 4, beginning with the appointment to the Pennsylvania Relay Service Advisory Board and continuing to include both items on page 5, ending with the complaint of Glendahaven versus the Pico Energy Company.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 6, it is recommended that the Commission adopt the proposed opinion and order in the complaint of Victor Oliver Jr. versus the Pennsylvania Electric Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Sweet. Under discussion, I do have a motion, so I will turn it over to Vice Chairman Sweet to preside.
Thank you, Madam Chair. You are recognized for the purposes of offering your motion.
Thank you. I will read my motion in its entirety. On March 9, 2017, Victor Oliver filed a complaint against Pennsylvania Electric Company, or Penelec, requesting a more affordable payment arrangement. It was a timely appeal of the Commission's Bureau of Consumer Services on January 12, 2017, their decision at BCS number 3489735, which dismissed his informal complaint. 2 hearings on the matter took place, the first on August 3, 2017, and the second on September 26, 2017. On November 2nd, 2017, the ALJ's initial decision was issued, which denied Mr. Oliver's complaint. On November 13th of 2017, Mr. Oliver filed exceptions in which he stated that he did not agree with the initial decision. On December 1st, 2017, Penelec filed its reply to exceptions. He presented no argument or evidence to support us extending him an additional opportunity to argue his case, and a review of the initial decision shows that it was correctly decided. As such, the exception should be denied and the initial decision affirmed. Therefore, I move that the ALJ initial decision be adopted consistent with this motion, and two, that the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. It's been moved and seconded. Is there any further discussion? Seeing none, all those in favor say aye.
Aye.
Aye. Opposed? Hearing none, the motion's passed 5-0. I will turn the gavel back over to you, Madam Chair.
On the matter as amended, there's no objection. We'll take the previous roll call. Seeing none, the matter as amended passes 5-0.
Who seconded it? Did someone second your motion, Madam Chair?
I will second it.
Okay, all right. Thank you. Continuing on page 6, it is recommended in an omnibus motion that the commission adopt the remaining 2 items on page 6.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 7, it is recommended that the commission adopt the proposed opinion and order in the complaint of Lonita Allen versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved. I'll second. Third.
Your
I
call.
think I heard Commissioner Kennard first, moving, Vice Chairman Sweet second. Under discussion, I do have a statement, and I ask that it be entered into the record in its entirety. In this case, I understand that the commission has limited jurisdiction when granting a payment arrangement due to a change of income or changed circumstances as defined in Chapter 14. I also agree that as a matter of law, the compelling facts in this case, which required a consumer with a good payment history to make a choice between compliance with a payment arrangement or renting transportation for a child to attend college, do not constitute a change of income or changed circumstances anticipated under Chapter 14. That being said, I will emphasize that PGW and our other utilities have much more flexibility under Chapter 14 than the commission does when it comes to reinstating or granting another payment arrangement in such circumstances. I again ask, as I have said previously, that our utilities, I would hope that our utilities would work with consumers whenever possible to deal with such issues. Any further comments?
I also have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before us today for consideration is a petition for rescission of the Commission's May 2018 final order filed by Lonita Allen in her complaint proceeding concerning Philadelphia Gas Works. The complainant did not file exceptions to the initial decision, which dismissed her complaint for lack of evidence that she is entitled to a second or subsequent Commission-issued payment arrangement or to an extension of the previous payment arrangement. Although it is clear that the complainant did not carry her burden of proof in this case, I would be remiss if I did not encourage the company to work with this complainant to ensure that her arrearage is satisfied by subsequent good faith payments. Ms. Allen had consistently paid 25 months from June 2015 to July 2017 of a commission-issued payment arrangement. She then paid a partial payment in July of 2017 because she had accrued additional expenses enrolling her daughter in college in Erie, Pennsylvania. I believe that Ms. Allen has exhibited a good faith payment history and consequently that the company should work with the complainant to have her pay incrementally to fully satisfy her arrearage. Thank you.
Thank you. Thank you. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Continuing on page 7, it is recommended in an omnibus motion that the commission adopt the remaining 2 items on page 7 and continuing to include both items on page 8 and the first 2 items on page 9, ending with the complaint of James Rich versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It should be noted that the last item on page 9 has been postponed until the public meeting of February 7th, 2019. Turning to page 10, it is recommended that the commission adopt the proposed opinion and order in the complaint and petition for interim emergency relief of Flynn et al. Versus Sunoco Pipeline LP.
Is there a motion to call up the matter for consideration?
So moved.
I heard Commissioner Place.
Second.
Second, Commissioner Coleman, second. On the matter, any discussion?
I have a motion, Madam Chair.
Vice Chairman Sweet.
Thank you. I ask that my motion be placed upon the record as if I had read it in its entirety. Before us is the order denying a petition for emergency interim relief and certifying material question issued by Administrative Law Judge Elizabeth Barnes on December 11th, 2018. The question presented is whether the December 11th, 2018 order of presiding Administrative Law Judge Elizabeth Barnes should be affirmed as complainants/petitioners have not shown that they are entitled to interim emergency relief under Commission regulations at 52 PA Code 3.6-3.8. The petition asks that the Commission directs Sunoco to cease operations of its pipelines carrying highly volatile liquids until the litigation of the formal complaint that was filed with the petition had been completed. This remedy requires the petitioners to establish that there was an emergency in the form of a clear and present danger to life or property, and to establish this emergency, 4 factors stated in our regulations must be met. The ALJ found that the petitioners did not satisfy this test and denied the petition. Her order is thorough and well-reasoned, and there is insufficient evidence on the record to support reversing it. The petitioners, I note, will now have a full opportunity to present their concerns and evidence to support their allegations of violations in the applicable complaint dockets. Therefore, I move, first, that the Commission answer the certified question whether the December 11th, 2018 order of Administrative Law Judge Elizabeth Barnes should be affirmed as complainants petitioners. It should be affirmed, the order, as complainants petitioners have not shown that they are entitled to interim emergency relief under the applicable Commission regulations. Second, that the underlying complaint in this matter, Megan Flynn, Rosemary Fuller, Michael Walsh, Nancy Harkins, Gerald McMullen, Caroline Hughes, Melissa Haynes versus Sunoco Pipeline LP at docket number C/2018-3006116 be returned to the Office of Administrative Law Judge for appropriate proceedings. And thirdly, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Vice Chairman Sweet. Is there a second?
Second.
Second by Commissioner Kennard. On the motion, is there any discussion?
I have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed in the record as if I'd read it in its entirety. As noted, before us today for consideration is the order denying a petition for emergency relief and certifying a material question issued by Administrative Law Judge Elizabeth Barnes in the above captioned proceeding. A petition for interim emergency relief was requested by several complainants in this matter. I concur with the ALJ's decision to deny the petition for interim emergency relief. With this action today, this case can now move forward in the underlying complaint proceeding to examine the numerous issues raised. The complaint proceeding provides a forum for the complainants and Sunoco to address the concerns raised here, including the changed circumstances with ME2, where the workaround pipe is now operational. I look forward to reviewing the comprehensive record to be developed in the complaint proceeding so that the Commission can make sound decisions on this issue. Thank you.
Thank you. Any further discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0 on the matter as amended. If there's no objection, take the previous roll call. Seeing none, the matter as amended passes 5-0.
And finally, on page 10, it is recommended that the commission adopt the proposed opinion and order in the joint petition of Consolidated Communications of Pennsylvania and Envoy LLC.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion passes 5-0.
Turning to page 11, and matters presented by Director Diskin and the Bureau of Technical Utility Services. It is recommended in an omnibus motion that the commission adopt all of the items on page 11, beginning with the petition filed by the City of Bethlehem, and continuing to adopt all of the items on page 12, all of the items on page 13, and the first 3 items on page 14, ending with the application of Hospital Energy LLC.
Is there a motion to adopt the staff recommendations?
Moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Is there any discussion on any of these matters?
Madam Chairman, I do have a comment on the PECO Energy Company Supplement number 12 that was filed.
Commissioner Coleman.
Thank you. I just wanted to commend PECO this morning on this matter. As many of you recall, over the years, we have approved various supplements for our natural gas distribution companies in Pennsylvania to extend natural gas service to those parts of their territory that had previously been uneconomic to reach. And so in approving those tariffs over time, we have been able to extend natural gas service to a variety of communities and customers across Pennsylvania. So this matter this morning is an increase in the dollar amount to the pilot that we had previously approved for PECO to $25 million to continue extending natural gas service to customers in Pennsylvania. So I just wanted to take a moment this morning to commend the company for the good work. This is consistent, by the way, with the efforts that this commission put forward with NARUC, the National Association of Regulatory Utility Commissions, in extending natural gas service, where we provided extensive expertise in explaining ways that commissions can extend natural gas service. So I think this is a great milestone this morning, and again, I want to commend the company for doing so.
Thank you. Any further discussion on any of these matters in this omnibus motion? Seeing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 14, it is recommended that the commission make the quarterly earnings report of public utilities public.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
I have a statement on the matter. Commissioner.
Commissioner's Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I read it in its entirety. Before us is the report by the Bureau of Technical Utility Services to the Commission regarding quarterly earnings of Pennsylvania utilities for the quarter ended September 30th, 2018, which maintains the proxy ROEs for electric utilities at 9.65, increases the proxy ROE for natural gas utilities and water utilities to 10.15 and 9.95, respectively. For electric utilities, as documented in the report, the discounted cash flow analysis indicates an ROE of 9.01 with one standard deviation of 8.51 to 9.51, down an additional 6 basis points from the previous quarter. While the capital asset pricing model analysis produces an 8.29 ROE, down an additional 28 basis points from the previous quarter. To put this into perspective, over the last 3 quarters of 2018, DCF-based ROEs have dropped from 9.21 to 9.07 to 9.01, while CAPM-based ROEs have dropped from 9.01 to 8.57 to 8.9. Despite these clear market signals of declining ROEs, the Commission proxy ROEs have remained fixed at 9.65 over the last 3 quarters. This fundamental analysis is further confirmed by declining industry-wide approved ROEs applicable to base rates have fallen to 9.55 for all of 2018. I presume that's not coming from me, but
Yeah,
bear with me.
hit the control button.
For electric distribution utility, I presume it's not the. For electric distribution only utilities, the average ROE authorized in cases decided during 2018 was 9.38 versus 9.43 in cases decided in 2017. Thus, when fundamental DCF analysis points towards higher ROEs, previous actions of this Commission have been to increase the proxy ROEs. Conversely, fundamental analysis points towards lower ROEs, as is again before us today. The Commission is maintaining the proxy ROEs, notwithstanding a regulatory environment that is relatively de-risked by multiple cost pass-through riders, distribution system improvement charges, reduced rate case regulatory lag. Additionally, most of Pennsylvania's electric distribution companies have been below industry average financial risk, with average equity ratios of 54.03% versus 2018 national rate case industry averages of 46.49%. Given comparative ROEs across the country, Pennsylvania's comparatively low financial and regulatory risk, analytically sound DCF and CAPM analyses, a decrease of 15 percentage basis points to 9.50 would be substantially more economically justified and wise, while remaining mindful of the value of gradualism. Similarly, for natural gas utilities, the DCF analysis indicates an ROE of 9.96% with one standard deviation of 7.17 to 12.75, up slightly from last quarter's 9.93, while the CAPM analysis produces an 8.88% ROE, down substantially from last quarter's CAPM ROE of 9.01. DCF analysis over the last 3 quarters reflects an increase of ROEs from 9.65 to 9.93 to 9.96, while the CAPM has produced a consistent and sizable decrease of 9.61 to 9.02 to 8.88. Thus, the DCF and CAPM methodologies do not provide similar guidance on ROEs this quarter. Of note, however, the upward DCF ROE trend is in no small measure driven by South Jersey Industries, which has an average growth rate of 11.78%, a clear outlier, with the next highest average company growth rate being 7.44. This example, the inordinate weight of one data point skewing the data set, illuminates the potential for unjustified variability using such a small barometer group. Distorting calculated DCFs both up and down based on one company or even one analyst. Calculations by S&P Global Market Intelligence's Regulatory Research Associates, while preliminary, reveal a likelihood that the average gas utility ROE authorized in cases decided during 2008 declined to 9.61% versus the 9.72% average for cases decided in 2017. Thus, our current proxy ROE is already well above the industry average, despite, again, a low-risk regulatory environment in Pennsylvania characterized by multiple pass-through riders and a DISC to mitigate rate case lag. Again, noting the financial risk of Pennsylvania's natural gas distribution companies is already relatively lower than national industry averages, with average common equity ratios of 52.44% compared to national industry averages equity ratios of 50.83% in 2018 rate cases. Notwithstanding this empirical view, this commission has increased the ROE from 9.95% to 10.15% over the last 3 quarters. Given relative ROEs across the country, comparative low financial and regulatory risks of the Pennsylvania NGDCs, combined with supporting DCF and CAPM analysis, a decrease of 10 basis points to 9.95% would be substantially more economically justified and wise, while remaining mindful of the value of gradualism. For water utilities, the base DCF calculation is at 9.67% with a CAPM result of 9.5. The existing ROE of 9.85 is already 18 basis points higher than the base DCF calculation. The proposal to increase the 9.85 value to 9.95 will increase this interval to 28 basis points without, as I argue above, any quantitative or risk-related justification. Additionally, are water utilities riskier than EDCs given DISC and Section 1329 acquisition parameters, as well as the recently effective legislation for the rainmaking treatment of the replacement of customer-owned lead service lines and wastewater laterals? I do not believe that this to be the case, and consequently believe that a minimum 10% basis point reduction in the water utility DISC ROEs to 9.75% is empirically sound and economically wise. I also respectfully disagree with the DISC ROE should, as has been argued, exceed the Commission staff's market-based equity calculations by a significant margin. Such a position is clearly contrary to central consumer protections embodied in Act 11 and can have the unintended effect of actually decreasing the rate of infrastructure replacement. Act 11 requires the DISC charge to be set at 0 if, in any quarter, data filed with the Commission in the utility's most recent annual or quarterly earnings report show the utility will earn a rate of return that would exceed the allowable rate of return used to calculate its fixed cost under the DISC. Embedded in this provision is the definition of a DISC, quote, a charge imposed by a utility to recover a reasonable and prudent costs incurred to repair, improve, or replace eligible property that is part of the utility's distribution system, end quote. This definition emphasizes reasonable and prudent costs, not costs in excess of a fair return on common equity in order to ensure a positive DISC. Secondly, by elevating the quarterly ROEs above market-based levels derived from long-held ROE and cost of common equity estimation methodologies, more revenues are paid to shareholders, and less is invested in the actual costs of system repair, replacement, and improvement. This is clearly contrary to the enumerated statutory goals of Act 11. Finally, and not least, the use of ROE figures that clearly exceed market-based estimates create unwarranted economic rents the utility ratepayers will have to bear. For these reasons, I respectfully oppose the adoption of proxy ROEs that are contained in this report. Thank you.
Thank you, Commissioner Place. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Commissioner Place.
Turning to page 15, it is recommended by Chief Counsel Pan-Q and the Law Bureau that the Commission adopt the proposed order in the petition of the Pike County Light and Power Company.
Is there a motion to call the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion. Any discussion?
I have a motion, Madam Chair.
Vice Chairman Sweet.
Thank you. Before the Commission for consideration is a petition of Pike County Light and Power Company, Pike, seeking a waiver from the Electronic Data Interchange, EDI, and customer switching time requirements of 52 PA Code 57.174 and of certain Commission orders relating thereto. Specifically, Pike requests that it be permitted to implement a password-protected online method for initiating customer switches, as the implementation of EDI would fail to be in the public interest due to its high costs. Additionally, Pike requests a waiver of the 3-day switching requirement, requesting 5 days should be required to perform many switches at one time. These same issues have been raised as part of Pike's June 2019 through May 2021 default service plan that is currently before the Commission. In that proceeding, the parties have submitted and the administrative law judge recommends adoption of a full settlement. That settlement includes the proposed approval of the same waivers outlined in the petition before us, as that settlement includes the same parties as this proceeding, specifically Pike and the Office of Consumer Advocate. And because the settlement is in the general public interest, Pike here should be granted the waivers outlined in its petition in a manner consistent with the terms of the settlement in the default service plan proceeding. The granting of these waivers is appropriate in Pike's service territory due to its small size compared to the relatively high cost of implementing an EDI system. Additionally, I believe Pike will make a good faith effort to perform switches within the 3-day time frame whenever possible. Therefore, I move that first, the petition of Pike County Light and Power Company be granted, and secondly, the Law Bureau prepare an opinion and order consistent with this motion. And I thank you.
You have heard the motion of Vice Chairman Sweet. Is there a second to the motion?
Second?
Second by Commissioner Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0 on the matter as amended. If there's no objection, take the previous roll call. Seeing none, the matter as amended passes 5-0.
Turning to page 16, and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge. It is recommended in an omnibus motion that the Commission adopt the first two items on page 16.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt ALJ Johnson's initial decision in the complaint of Kimberly Parish versus the Pennsylvania Power Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Under discussion, I do have a motion, so I'm going to turn it over to Vice Chairman Sweet to preside.
Thank you, Madam Chair. I'll try to get this PUC parliamentary procedure right this time.
We'll just nudge you every couple of times.
Fail again in a valiant effort. You are recognized for the purposes of offering a motion.
Thank you. I ask that my motion be spread upon the record in its entirety, and I will summarize it for you. On April 4, 2018, Kimberly Parish filed a complaint against Pennsylvania Power Company, or Penn Power, because she had received a termination notice, had defaulted on a commission-issued payment arrangement, and was requesting a more affordable payment arrangement. In November of 2017, when the initial payment arrangement was granted, it was based upon a 3-member household with a gross monthly household income of $2,167. The ALJ denied the complainant's request for another payment arrangement because the household income did not include the decrease by 10% consistent with Section 1405D under the Public Utility Code. However, consistent with Section 1405E of the code, the complainant would be eligible for reinstatement and extension of her November 2017 payment arrangement if she defaulted due to an increase in the number of dependents in the household. In November of 2017, the payment arrangement was based upon a 3-member household consisting of Ms. Parish, her husband, and her minor son. During the hearing, Ms. Parish claimed that her household now consists of 4 people: Ms. Parish, her husband, her minor son, and now her mother-in-law. The mother-in-law provides the household with no income because she has a disability application pending. However, the ALJ held that there is no substantial evidence in the record to establish that Ms. Parish and/or her husband are legally obligated to support the mother-in-law. Therefore, the ALJ concluded that the complainant's mother-in-law is not a dependent of Ms. Parish within the meaning of Chapter 14. With this, I disagree. Dependent is not defined in Chapter 14. However, the Commission has regarded adult children as dependents. For example, in Hayes versus Philadelphia Gas Works, the Commission held that a customer's 24-year-old son had no income and moved in with the customer after a Commission-issued payment arrangement did increase the customer's number of dependents, thereby making the customer eligible for a 6-month extension of his payment arrangement. I believe that the complainant here has proven that the addition of her mother-in-law to the household qualifies as a significant change in circumstances under Chapter 14. As such, Penn Power should reinstate, the payment arrangement and extend it by 6 months consistent with Section 1405E of the Public Utility Code. Therefore, I move, 1, that the ALJ's initial decision be reversed consistent with this motion, and 2, the Office of Special Assistants draft an opinion and order consistent with this motion.
Thank you. Is there a second?
Second?
It's been moved and seconded. All in favor signify by saying aye.
Aye.
Aye. Opposed? The motion is carried 5-0. As amended, may I assume the previous roll call? Seeing no disagreement to that, the previous roll call is adopted.
And sorry to jump in, but for the sake of the record, we should probably note that the second was Commissioner Place.
Certainly.
Thank you very much.
Okay.
I'll try
Attorney-
again a third time later.
He's working on it.
He's working on it.
In my old days in the General Assembly, when I chaired a committee, all I asked for were negative votes. And if there were any, they were ignored.
Turning to page 17, it should be noted that the first item at the top of page 17 has been postponed to the public meeting of February 7th, 2019. Continuing on page 17, it is recommended that the Commission adopt ALJ Cheskas's recommended decision in the petition of Pike County Light and Power Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion, I do know that I have a statement to read for the record. Ask that it be entered into the record in its entirety, but I will give an abbreviated oral version of it. So before the Commission is the proposed statement of Pike County Light and Power's Default Service Plan, or DSP. The settlement provides that 50 to 75% of Pike's default service energy supply will be procured via 1-year hedges, with the remainder being filled with spot market products. Further, the settlement permits Pike to solicit brokers and counterparties to procure necessary AEPS credits during the term of the plan. Act 129 states that default service procurement shall include a prudent mix of spot, short-term, and long-term contracts. However, the Commonwealth Court has previously ruled that the Commission acted within the bounds of Act 129 when the Commission approved Pike's 2011 default service filing that included no short-term or long-term contracts. In that decision, the Court determined that the Commission's approval of a spot market-only procurement in light of the prudent mix standard was lawful, since the Commission properly considered the possibility of including short-term contracts, including financial hedges. The Commission ultimately concluded that the additional benefits of a financial hedge would not be justified by the additional cost. The record here does not reflect the same consideration, that the same consideration was given. I note that this proceeding does take a step in the right direction towards Act 129 compliance, as Pike is now including short-term contracts in the form of 1-year energy hedges. These 1-year hedge products are designed with a fail-safe that reverts back to the spot price product should the bid results not meet certain customer protection criteria. Such products are appropriately designed to balance the risk of cost with the benefit of price stability. While acknowledging Pike's unique situation as a small EDC interconnected to the New York ISO, the inclusion of these hedges exhibits the potential for Pike to consider short and long-term contracts in its portfolio. To that end, I contend that similarly designed products meeting the long-term definition in Act 129 should also be included in this DSP to comply with the prudent mix standard. Such products could be energy tranches or energy blocks. Further and potentially even more practical, the long-term contracts for AEPS credits could be utilized by Pike. Such long-term contracts, whether energy or credits, could be similarly designed to instill customer protections like the one-year energy hedge product included in the instant portfolio. Since the settlement fails to include any long-term contracts and fails to empirically substantiate the omission of long-term contracts, I must respectfully dissent. In closing, consistent with Act 129, I respectfully ask Pike and all other EDCs to include long-term contracts in their default service portfolio to the extent long-term contracts are not utilized. I ask those EDCs to include empirical data supporting their mission. Any further discussion or comments?
I do have a comment.
Vice Chairman Sweet.
It is clear in this proceeding that Pike's plan does fail to include long-term contracts. However, I'm not inclined to unravel a settlement entered into by all the parties, especially when Pike has provided evidence to help support its use of spot market purchases. Specifically in 2016, when the Commission approved Corning's acquisition of Pike, the adopted settlement included an electric supply agreement between Pike and Orange and Rockland Utilities. Per that agreement, Pike procures its default supply from the New York ISO spot market. The same methodology is included in the plan before us, as the electric supply agreement is effective through August 31, 2019, with the possibility of 3 one-year extensions. As such, I agree with the settling parties that the continued use of the spot market methodology is appropriate for the term of this 2-year plan. I note that Pike has worked to help address the Office of Consumer Advocate's ongoing concern regarding price volatility by including a hedging methodology that would convert portions of the energy purchased from spot markets to fixed rates. This proposal was supported by the OCA as a way to ensure more price stability. Therefore, I will vote in support of the recommended decision adopting full settlement. However, I reiterate my agreement that is expressed in the past with Chairman Brown's past statements on the issue of a prudent mix of contracts, that electric distribution companies must either include all 3 types or provide clear evidence as to their omission. Additionally, I note that an important factor in my supporting this default service plan is that it is only a 2-year plan. As the electric service agreement expires in August of this year, with the possibility of 3 one-year extensions, it would behoove Pike to take into serious consideration the contract mix requirements of Act 129 in both determining whether to continue its agreement with Orange and Rockland and in developing its next default service plan. Thank you.
Thank you. Any further discussion?
I also have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed on the record as if I had read it in its entirety. As noted before us is the petition for default service plan and waiver of commission regulations by Pike County Light and Power Company, filed on June 12, 2018 with the Pennsylvania Public Utility Commission, and the joint petition of all parties for settlement for default service beginning on May 31, 2019. Pursuant to the settlement, Pike may place 1-year hedges in both years of the default service plan. The settlement does contain reporting requirements regarding the results of the procurement, the number of counterparty bids received, and the forward market prices against which the bids were evaluated, as well as a report detailing, if a failure of the hedging program were to occur, the knowable circumstances of why no acceptable bids were offered, and what plans the Commission would have for redoing their procurement. However, the settlement does not provide any analysis of the DSP in its entirety. For that reason, I encourage Pike to provide a cost analysis comparing the cost of its current DSP and the cost of the DSP approved for service herein for the next 2 delivery years beginning May 31, 2019. While these results may be temporal in nature, depending on overall spot market trends from year to year, They may prove nevertheless helpful going forward in providing an initial foundation of knowledge surrounding the prudency of DSPs in Pennsylvania. Thank you.
Thank you. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? I will be voting in the negative. The motion passes 4-1, noting my dissent.
It is recommended that the commission adopt ALJ Long's recommended decision approving the joint petition for settlement regarding the Borough of Indiana.
Is there a motion to adopt staff recommendation?
So moved.
Second?
Motion by Vice Chairman Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And at the bottom of page 17, it is recommended that the commission adopt ALJ Salapa's initial decision regarding the complaint of Michael Stephen Sherman versus Verizon, Pennsylvania.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion? Oh, under discussion, I do have a motion, so I'm going to turn it over to Vice Chairman Sweet to preside.
Thank you. The chair is recognized for the purpose of offering your motion.
I ask that my motion be spread upon a record in its entirety, and I will read the abbreviated version of it. On July 26, 2018, Michael Stephen Sherman, PC, filed a formal complaint against Verizon Pennsylvania LLC, raising concerns with billing for services and the reliability, safety, and quality of the voice service and equipment that relied on voice over internet protocol or VoIP technology. Verizon filed preliminary objections alleging that the commission lacked jurisdiction over VoIP service. The ALJ construed the preliminary objections to be a motion for judgment on the pleadings and dismissed the case with no hearing. I disagree with granting a pre-hearing dismissal without further consideration of whether or not the exceptions contained in the VoIP Freedom Bill apply to commission jurisdiction in this case, including whether the complainant's 911 service is involved. As such, this matter should be remanded to the Office of Administrative Law Judges Mediation Unit for further fact-finding and resolution. If mediation fails, the matter will proceed to hearing. Therefore, I move that, 1, the ALJ's initial decision be vacated consistent with this motion. 2, the matter is referred for mediation to the mediation unit of the Office of Administrative Law Judge, and the parties are directed to actively participate in good faith. 3, that the mediation and resolution of this matter is successful. If the mediation and resolution of this matter is successful, appropriate and timely notice will be filed with the commission. 4, if the mediation does not succeed, this matter will be referred to an appropriate evidentiary hearing before the Office of Administrative Law Judge. And 5, the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. Is there a second?
I will second it.
Seconded by Commissioner Place. Thank you. Is there any further discussion? Commissioner?
Vice Chairman, I do have a statement on this case.
You are recognized.
Thank you. As indicated in the chairman's motion, this is a dispute over the commission's jurisdiction over voice over internet protocol service. I do agree that this case does need to be remanded. However, I don't agree with the rationale in the motion that gets us to that point. My statement this morning goes through that in detail, and I will spare the reading of that statement and just ask that it be entered into the record as though I read it in its entirety. Thank you.
Thank you for your mercy. Most appreciated. Commissioner Kennard, you are recognized.
I would associate myself with the comments of Commissioner Coleman, why I believe that the General Assembly severely restricted commission jurisdiction over IP and VoIP services. There is substantial factual ambiguity in this case, which does warrant a remand. Thank you.
Thank you. It's been moved and seconded. Any further discussion? If not, all those in favor say aye.
Aye.
Aye. Opposed? Noting the caveats expressed by Commissioners Coleman and Kennard, the motion is adopted. Is there any objection to taking the same roll call with the same caveats on the motion as amended? Seeing none, the motion as amended is carried 5-0.
5-0.
Seeing no grimaces from the secretary,
Yeah, I just wanted to make sure
I
you
finally
have the vote.
pass the course.
Wanted to make sure you had 3. Madam Chairman, that concludes the regular agenda. Turning now to the carry-in agenda at the top of page 1 of the carry-in, it is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order in the complaints of the Office of Consumer Advocate versus Hidden Valley Utility Services.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And the final item on the carry-in, it is the motion of Commissioner Place regarding investigations into default service and PJM interconnection settlement reforms.
Commissioner Place, you are recognized for your motion.
Thank you. Madam Secretary, I ask that my motion be placed into record as I had read it in its entirety. On September 15, 2007, the Commission established a default service policy statement applicable to customers who have not chosen an alternative electric generation supplier who contracted for electric energy that is not being delivered. Over that 11-year period, a number of fundamental changes have occurred in Pennsylvania's retail electric industry. Most notable is the continued deployment of smart meters capable of hourly or sub-hourly interval meter reads, and the development of mechanisms for the availability and sharing of this data to customer agents. According to current electric distribution companies' smart meter plans, most large EDCs in Pennsylvania should have fully functioning smart meters by 2020. Coincident with this installation of smart meters, EDCs are developing updated wholesale settlement procedures and integrated cost allocation methods for energy, capacity, and transmission costs via actual hourly energy use as adjusted for losses and other factors, as well as tickets assigned to individual customers based on allocation methods for capacity and transmission documented in each EDC's attachment M2 in the PJM interconnection tariff. With the installation of smart meters, the long-term benefits associated with positive customer usage behaviors can be flowed back to customers if charges in retail rate design for previously non-interval customers are more aligned with wholesale cost allocation methods. Absent a change in retail rate design for default service, such benefits will only flow to the large wholesale LSCs, such as wholesale DSPs and EGSs. Without direct methods for rewarding customers in a timely manner for positive behaviors, customer responses to market prices will be stunted or suboptimal. To the extent wholesale cost allocations align reasonably well with true cost causation principles, then such a system would provide more rational pricing signals to minimize long-term costs. To this end, I propose opening a proceeding to discuss how this commission should mesh smart meter investments with smarter default service rates and smarter cost allocation methods. Lastly, PJM will be filing shortly to significantly alter energy and ancillary market pricing mechanisms, which are likely to significantly shift costs from wholesale capacity markets to wholesale energy markets. Such a shift in market design may have an impact on optimal default service rate design. As a starting point, I've posed a number of questions regarding various topics for interested parties to comment on, including 1. Review of wholesale cost allocation methods reflected in attachment M2 in the PJM tariff filed at FERC. 2. How PJM energy-related costs should be recovered in default service rates, including a discussion of various time of use, critical peak pricing, peak time rebates, and hourly price structures. 3, how PJM demand-related costs should be recovered in default service rates. 4, how such changes in default service rate design will impact default service procurement. And lastly, a review of long-term contracting procurement in default service plans. Based on the feedback received, the Commission may propose to amend our default service regulations, default service policy statement, or issue other orders as appropriate. Given the extensive list of issues addressed above, I recommend that the Office of Competitive Market Oversight, Law Bureau, and the Bureau of Technical Utility Services guide the process for comments and stakeholder meetings and final recommendations regarding the issues outlined in this motion. In addition, I recommend that comments be submitted to the Commission within 90 days of the entry date of this order and reply comments submitted within 30 days thereafter. Therefore, I move that 1. The Office of Competitive Market Oversight and Law Bureau draft an opinion and order consistent with this motion. 2. Comments in response to the Commission's order at this docket be filed no later than 90 days of the entry date of this order. 3. Reply comments to this docket be filed no later than 120 days of the entry date of the order. 4. The Office of Competitive Market Oversight, Law Bureau, and the Bureau of Technical Utility Services are directed to convene stakeholder groups, if necessary, to discuss the submitted comments and other issues, including any proposed changes to the Commission's default service policy statement at 69 PA Code at Section 1801 at SEC and/or regulations. 5. The bureaus are directed to develop a recommendation to the Commission regarding wholesale cost allocation and default service rate design and procurement reforms no later than 9 months of the entry date of this order. Thank you.
Thank you. You have heard the motion of Commissioner Place. Is there a second?
Second.
Second by Vice Chairman Sweet. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all of the agenda items to be considered today.
Thank you very much. Before we gavel out, we just want to acknowledge that after we gavel out, we will have some staff retirement and recognition, so we ask that you please remain in your seats. Without any objection, the meeting is adjourned.